Hello and good afternoon, everyone, and thank you for attending the Surviving the Shutdown, What Every Distributor, Dealer, and Franchisee Needs to Know webinar presented by Foley. Today we will discuss key issues and key response items to keep in your emergency survival toolkit for your business. Before we get started on today's presentation, I'd like to go over a few housekeeping items. For those of you who may have questions about any of today's topics, we invite you to type them into the Q&A widget on your screen. We will try our best to answer all of the questions at the end, time permitting. However, if we do not get to your question today, we will be sure to follow up via an email. If you experience any technical difficulties with the webinar platform, please refresh your browser or see the webcast help guide on your screen. A copy of today's slides will also be available in the resource list widget. And as a final note, a short survey will appear on your screen, and we appreciate it if you would provide us with feedback on today's webinar to help us improve webinars in the future. And now I will turn it over to our presenters.
Thank you. Good morning or afternoon, depending upon what time zone you're in. I am Mike Lockerbie, one of the co-chairs of Foley's distribution and franchise practice. I actually never thought that I would be presenting a webinar in PowerPoint with a virus background, but these are obviously unusual times. Before I introduce some of the other speakers, including my partner Mike Crossan in our Government Solutions Department, I wanted to give an overview of what we are going to cover in the next hour. I realize that most of the participants, although not everybody, is actually either a manufacturer or a franchisor rather than a dealer, distributor, or franchisee. But for today's presentation in particular, that distinction really doesn't matter, because I think it's obvious to everybody on this call, which is why you're here, that a manufacturer needs healthy distributors and dealers to sell its and service its products, and a franchisor needs healthy franchisees to keep its franchise system intact and hopefully grow it. Needless to say, the current pandemic has placed many businesses, large and small, in economic stress. And today's program is the first of a series that our distribution and franchise practice group will be presenting to help companies survive during and then hopefully recover from the pandemic. The emphasis today, however, is on short-term relief. And in that regard, you'll see a link at the bottom of each slide and also on the next slide to our Coronavirus Resource Center, which is updated daily and has a lot of materials on the topics that we're covering today, and then many, many more. Our first topic, though, is going to be SBA loans under the CARES Act, which everybody's interested in, and eligibility for which just opened up a week ago Friday. And there are efforts underway, which Mike Crossan will address briefly in a moment, to increase the amount of funding. We also want to touch very briefly on a few other subjects: bankruptcy and restructuring, force majeure clauses, insurance, and then how all this plays out in light of state franchise and dealer relationship laws, keeping in mind that other than the loans themselves, we're not going to be able to do a deep dive into the other topics today, but we will have upcoming webinars that address those in greater detail. With respect to the Coronavirus Resource Center, as I said, there's a link here, and that is literally updated every day, and it has written materials that go beyond what's in these slides on every topic we're talking about, including the loan program and the supply chain, force majeure, and many, many others. In a minute, I'm going to turn the floor over to Frank Murray, one of our partners in D.C., who has been spending more time than he probably would like dealing with the SBA loans available under the CARES Act. But before he does that, Mike Crossan, could you please just give us a brief update on what is going on or not going on in the government right now in terms of trying to get more money for these programs?
Sure. Mike, happy to do that. This is Mike Crossan. Look, I mean, the truth of it is that as we're speaking, things could change. So I may be yesterday's news before I finish speaking, candidly. But let me tell you where we are, as I understand it at the moment. As you might imagine, the Senate Republicans and Democrats don't necessarily see eye to eye on what happens next. The Majority Leader, Senator McConnell, has proposed fixed legislation, in effect, that is CARES Act fixed legislation, based on the premise that there simply wasn't enough money put into the Paycheck Protection Program provisions in the CARES Act to accomplish its purposes, and had proposed legislation to increase the original $349 billion number by 251, bringing the Paycheck Protection Program funding to $600 billion. The Democrats had come back and suggested variations on that theme, suggesting that there'd be $250 billion in additional help for small business through about $185 billion increase to the Paycheck Protection Program and $65 billion in an increase to the Economic Injury Disaster Loan Program. Also $60 billion of the Paycheck Protection Program would be required to guarantee loans by community financial institutions. Specifically, it would require that $15 billion would need to guarantee loans by institutions with $50 billion or less of consolidated assets, and $45 billion would need to guarantee loans by institutions with $10 billion or less of consolidated assets. It also would provide $100 billion for the Public Health and Social Services Emergency Fund for hospitals, community health centers, and health systems, $150 billion for state and local governments, and a 15% increase to the maximum supplemental nutrition assistance program, or SNAP. That's the difference between the two right now. I can't honestly tell you where I think it will go today, or if it will go anywhere today. It would require unanimous consent for anything to be passed today, and if that isn't accomplished, it will wait till next Monday to start in an effort to come to more meaningful or complete and enacted legislation. So that's where we are at the moment.
Great. Thank you, Mike. Now we'll turn the floor over to Frank Murray, who will be able to tell us that regardless of what Congress does or doesn't do today or next week, what the current state of the law is with respect to SBA loans under the CARES Act. Frank?
Thanks, Mike. So we'll discuss a little bit of background on the SBA loan assistance to small businesses. That was sort of the framework that existed before the CARES Act, and is kind of built upon in the CARES Act, at least with the Paycheck Protection Program is a new program. The Economic Injury Disaster Loan Program has been out there for a number of years, but they're doing some tweaks to it to sort of make it more attractive and more useful to businesses that are suffering economic injury from the coronavirus pandemic. So under the SBA's statutory authority, the Small Business Act, it is authorized to provide loan assistance to small business concerns under, there are two sort of prongs. One is Section 7A and one is 7B. And 7A loans are generally to provide financing for general business purposes. Hold on a sec. So the SBA will guarantee the loan. It's usually one that you're as a small business coming in to either open a small business or expand your small business. You're looking for general financing, as opposed to the Paycheck Protection Program loans, which is really that you're in dire straits and need this loan to survive. And so under this program, there's typically been a credit elsewhere test, where one of the things they look at is, before we're going to give you an SBA guaranteed loan, that you're going to have to show that you're the kind of small business that doesn't really have access to capital elsewhere, where the SBA wouldn't be providing the guarantee. Now, 7B loans are what the Economic Injury Disaster Loan Program falls under, and those are generally loans to help a small business recover from a disaster, and there can be a lot of people would think in terms of disasters, the physical disasters, the hurricane, the flooding, and they certainly can be physical disasters that you're seeking to rebuild your infrastructure from. But there can also be sudden events that cause substantial economic injury that are disasters, even if they don't do any physical damage to your property. And this pandemic is a textbook example of that. And so you can get an economic injury disaster loan when there is a disaster, it causes substantial economic injury, and that is defined in the regulations as being unable to meet your obligations as they mature or pay your necessary operating expenses. Just sort of having a loss of profits or a little bit of a reduction in sales is generally not good enough. But again, given where we are now, it's very easy to see that businesses are going to be able to make that showing for an economic injury disaster loan. So Senate passed, Congress, both houses have passed the CARES Act on the 27th of March, 2020, and was signed into law by President Trump on that same day. And as it's mentioned, $349 billion is for the PPP, the Paycheck Protection Program. And they also appropriated $10 billion for emergency EIDL, economic injury disaster loan grants. And so that's kind of this pool of money from which you can go in and apply for an economic injury disaster loan and ask for a $10,000 cash advance. And they will give it to you if you're eligible. And even if your application is denied, you're not required to pay that back. So that's kind of a nice benefit to give you some immediate cash if you're applying for that. But most of what I'm going to focus on is going to be related to the PPP, the Paycheck Protection Program. That's been the bigger focus for businesses. It's a bigger pool of money. And really what makes it so attractive is that if you follow the rules for the program, it's not really a loan so much as it's a grant. It's fully forgivable if you follow certain procedures and spend the money in certain ways. So it essentially amounts to a grant, free money from the government, and that's why there's been such wild demand for this, and why there's concern that the money's going to run out, and why there's interest in trying to get more money into the program. So a couple of the features that are particularly designed to make this more accessible to everyone and to streamline the process is that there's not a personal guarantee or collateral required. Hold on a sec. So I'm trying to take control of the slides here. So there, and on that slide, the credit elsewhere requirement is waived again. So there's not a lot of due diligence that needs to be done into the finances of the applicant. The loan forgiveness is highlighted there is a big plus, and then there's some special flexibility for hospitality or food services companies in the restaurant and hotel business. And then also payments are deferred for the first 6 months. So within that first 6 months, you don't have to make payments. You can apply for loan forgiveness, and if it's forgiven, essentially the SBA will end up paying the money to the lender, and you will not. So here's some of the features of the EIDLs for COVID-19 pandemic. It's a maximum amount of $2 million. It's a longer-term loan. It is a loan you have to pay back, but it's on a longer term. I think it can be up to 30 years. And there is no loan forgiveness. But if you had one, and so certainly those were an existing program. The PPP was brand new with the CARES Act. If you apply for an EIDL for COVID-19 issues and got one before the PPP was instituted, you can then try to roll it into a PPP loan and get that amount forgiven if you, again, follow the PPP procedures, which we'll talk about in a minute. So at any rate, then we have the eligibility for businesses. So this is one of the key issues that people have been kind of grappling with the SBA, because they haven't provided a ton of guidance. They provided a little bit more. But certainly if you are a small business under the normal SBA size standards, then you are eligible. And so the SBA issues the size standards for industry codes under the NAICS code system, North American Industrial Classification System, I think is what that stands for. If there aren't some that have a revenue-based standard, a receipt-based standard, but the SBA, to sort of simplify things with the PPP, has said if you have 500 or fewer employees, then even if you would be large under the receipts-based standard for your industry, you're going to be considered small. So that's another factor that has made more than the normal small businesses eligible. Sole proprietorships, self-employed individuals, and independent contractors are also eligible to file for a loan, and they can. And then I wanted to highlight here that if you are in the NAICS codes that begin with 72, which is the accommodation or food services industry, there's a special provision that says if you employ not more than 500 employees per physical location. So you could be a company that has several restaurants, and as long as you're not employing more than 500 employees at each individual restaurant location, you would be eligible even if you have far more than 500 collectively. So that is a special category for that industry alone. And so that provided an example here with one particular NAICS code in that industry for fast food or fast casual restaurants. At any rate, that would be the rule that would apply for them. So what has tripped up a lot of folks who are not used to applying for SBA size standard issues or figuring out whether they're eligible under them is the affiliation rules. The SBA will affiliate or will aggregate the employees and the revenues of affiliated entities. The thought behind that is, say Amazon spun off a small subsidiary with 300 employees, and then try to say, hey, look, I'm Amazon spin-off co. And I only have 400 employees. I'm small. Well, clearly, it's part of the Amazon empire. It's not a true small business. And so if it's controlled by Amazon, they're going to aggregate all the Amazon employees. So there is an affiliation concept where you look for control. And the concept of control is whether if you are controlled by an entity, then you are an affiliate. So if you have a parent, they are your affiliate. If you control entities, if you have subsidiaries or otherwise can control entities through management or otherwise, they are your affiliates. And then the third category is if you are under common control with other entities. So, if you are part of a larger family, then all your sister companies are affiliated as well. So that is how you are supposed to count your employee count, and under the normal SBA rule, you're supposed to include the employees of. Let me go back a slide there, because just wanted to touch on this. So the normal rules say to include employees of domestic and foreign affiliates in the employee count. There is some guidance that the SBA has issued for the PPP program specifically that invokes U.S. employees whose primary place of residence is in the United States. So there's at least an available reading of their guidance that says you would just consider the U.S. resident employees when doing that count. Next slide. So there are three categories of businesses for whom the affiliation rules are waived. Again, the food services accommodation industry gets a special waiver for if you have 500 or fewer employees. It's not clear to me how that interplays with the 500 or fewer per physical location. It may end up being a wash with that anyway, but there is that waiver. And then if you're operating as a franchise that's assigned a franchise identifier code by the SBA in their SBA franchise directory, then there's a waiver of the affiliation rules to you as an applicant for a PPP loan. And finally, if you've received financing from a small business investment company, you have a waiver. Next slide.
Frank, this is Mike Lockerbie. If I could jump in for a minute. We had one question already about whether anyone had any intelligence about the extent to which the SBA is being stringent or lax with respect to the affiliation rules for companies that are not franchises on the SBA franchise directory. And I know that I personally haven't. We've to date, many of our clients that don't use the F word to characterize their relationships with dealers and distributors. The main challenge has been getting their agreements on the franchise registry, but I wanted to find out whether you or any of the other presenters has so far encountered a loan application for a non-franchise company where this issue has come up.
Well, what I would say is that there has not been a whole lot of guidance that the SBA has issued. They flagged what the 4 tests for affiliation that they are using for the business loan program and say that those apply in the context of the PPP. But there's not, I think what you're running into is that they've made this a very much a self-certification system where they've told the borrowers that they can rely on, they told the lenders that they can rely on the borrower's self-certifications and that the borrowers, the lenders don't have to really delve into and sort of do their own cross-check of the affiliation analysis that the borrower is doing. So in that regard, I think there has been a little bit of a relaxation, not on the letter of the law, but in terms of how it's being applied. Because in a normal, more regular SBA 7A lending process, there's probably more regular oversight by the SBA in terms of looking at the application and assessing, are there some affiliation issues here that we need to delve into. But this is so self-certification based that there is not the time to do that without holding up the process tremendously. So what I'd say is on the books, they've said the affiliation applies. The one thing that seems to be a little bit of an apparent relaxation is this language they've used about employees whose primary place of residence is in the United States seems to limit the counting of the employees to U.S. resident employees, which is not how they normally do things for other programs. And so that might be a little bit of a relaxation, but it's a little bit unclear how they're going to apply this as it goes.
Let me comment on that if I could for a second. This is Mike Cross, and I agree with everything Frank said, but I think we all ought to also keep in mind that much of what's going on under the Paycheck Protection Program relies upon borrower certification, and that when we ultimately come around to an audit of all of these loans, and we will, those borrowers or those certifications will be looked at hard. And I do think that people should at least be cautious to try as best they can to fit within the law. The complication for all of us has been that, for instance, a recent guidance document was issued by the SBA that brought up the point Frank made a moment ago about 500 employees in the United States. In all candor, if somebody had asked us that question before that guidance document was issued, we would have ended up on the opposite side of that issue. And I don't know that that guidance is right. Guidance is not law. Statutes are law. Regulations are law, as long as they're authorized by the statute. But guidance documents are not law. Now, they may well have to forbear in exercising or pursuing somebody who has relied on that guidance. But people should be careful is the point. The certifications are, they're going to be looked at. That's all.
Yeah, so I think that's a valid point, and what I would say, I kind of, we can harken back to one of the more close, there's no real analog to this particular, economic disruption we're suffering, but 2008, 2009, there was a stimulus bill, a large one, largest of its kind at the time, that put a lot of money out for projects to generate employment. And, one of the things we saw, particularly with relation to some of the grant conditions that went with some of that money, is that at the time everybody was all for pushing the money out and getting people employed to deal with the immediate crisis. But then after the crisis passed, then the OIG started to come in and they started to audit the programs heavily, and they would start finding things that said, you know what, you didn't follow these grant conditions, pay this money back. And so I do think, as Mike pointed out, that it is self-certification based. There are some ambiguities in exactly how the SBA is applying some of these rules, but there are other areas which, may not really be that subject to ambiguity. And so, while there's gray areas, you got to be careful that you're really in a gray area and not one that's just a lighter shade of black or a darker shade of white. And make sure that when the audits come, you're not getting accused of doing something. And there was another question about affiliation while we're on that topic, about whether the rules seem to overly impact companies with investors that have complicated affiliate status like venture capital or venture-backed startups. And the questions are there ways, exceptions or ways to work through the affiliate rules for the PPP loan. What I would say on that is, the affiliation principles are again geared towards control. So just the fact that you have a minority shareholder that has an investment, it does not necessarily make you, and in the abstract would not make you an affiliate of that investor. But where problems arise is that even if you're a minority shareholder, if you have the ability to essentially block certain actions by the board of directors or to prevent a quorum for the transaction of business, and those are some minority shareholder rights that are often worked into agreements, then you can get what's called negative control. So that tends to be where the problems arise in the business loan context, is that there's some negative control issues. And so what they've said in the guidance documents that they released, they made clear is that if you amend your operating agreement or the operative corporate document to take away those control issues, then you can certify honestly that you've resolved the issue before the loan. You need to do it before you put in the loan application, but they've given that avenue to look through. So I do think those are things to look at if you're a minority shareholder. The test that the SBA has sort of reinforced for these business loans says if you're a minority shareholder but have the ability to prevent a quorum or block action by the board of directors, then that can be seen as control. Now, well, on that point, I would say that it can be kind of a fine distinction between the types of actions that can be blocked or not. If you have the right as a minority shareholder to prevent the company from filing for bankruptcy or dissolving, that's probably not one that's going to be seen as an ability to control the company. That's sort of just protecting your investment. But there are a lot of times where you have the ability to approve or reject more mundane things like a budget or hiring or firing of people, or you can appoint a lion's share of the directors, et cetera. So you have to look at those parts of the operating agreement, even if you're a minority shareholder, and see. And if you can sever those control issues, then you have a good argument to come in and say, not an affiliate. So not going to spend too much time on this because we've kind of touched on it already, but in terms of the number of employees, there's not real explicit guidance, although they did put out an FAQ recently that did confirm that you can use a 12-month period, which is what the regulation here talks about, is using an average number of employees over a 12-month period as opposed to a one-time snapshot is how they recommend doing it. And they have indicated that you can use either the 12 months that you calculate your payroll costs across, or the immediate 12 months prior to the loan. A lot of folks who are using the payroll cost calculation are using calendar year 2019, and that's fine. What they didn't officially clarify is whether part-time and temporary employees are counted the same as full-time. That's what the existing SBA rules say, and so certainly you'd be safe doing that. But they haven't officially spelled that out in the guidance. So payroll costs have certain defined elements under the statute and in the rules that have been issued by the SBA. And so it's largely payments to employees for salary, wage, and commission. It covers their benefits, payment for vacation, medical, dental leave. If there's been an allowance for dismissal or separation, group health benefits, insurance premiums, and state and local taxes assessed on the employee's compensation. There are certain also defined exclusions from payroll costs that you have to take out of your payroll cost calculation. And, the most important, or not the most important, but two of the more obvious ones are the portion of the employee compensation in excess of an annual salary of $100,000. And then another one is the last bullet there, compensation to non-U.S. resident employees. So if you do have any employees who are not U.S. residents, essentially they're, I don't know if you're on the border with Canada and somebody comes across the border, but if you have any people who fall in that category, then that would be excluded. And then if you have someone who made more than $100,000 over the 12-month period, and that's in salary compensation, it's not including benefits. The SBA clarified this in one of the FAQs, that you're not looking at the value of their health benefits or things like that. It's pure compensation. And so if they're receiving compensation over $100,000, then you can count the first $100,000, but not anything further. So there are also certain authorized uses of the loan, and those are listed here. One of the primary ones I want to emphasize, and emphasize in the last bullet, is payroll costs. And so this was not something in the statute itself, but the Treasury and SBA have implemented in their rules for the PPP, and that is that there's a requirement that you spend 75% of the loan proceeds on payroll costs. And again, that's partly in keeping with the nature of the program. It is the Paycheck Protection Program, and so it's meant to protect the paychecks for the workers first and foremost, but also provide some additional money for you to spend on, as a business, on rent or utilities or mortgage interest. So that's why it's a 2.5 times your monthly average payroll for an 8-week period is the idea for the forgiveness. So it's a little bit more than what you'd be spending on your average monthly payroll. So there are some ability to spend some costs on other non-payroll things that are listed here. But the lion's share, 3/4, has to go towards the payroll costs. Loan forgiveness. Now, this is obviously of extreme interest to the people who are taking the loan, but the very specific nitty-gritty of this process has not been spelled out yet by the SBA. Right now, the focus is getting the loans out the door. Loan forgiveness is seeing a little bit more of a, next couple of weeks issues that they can get the rules out on it. So I think we'll see more specific guidance from them on loan forgiveness. But essentially, the way the statute's laid out is that there are 4 categories of costs that you can spend the loan proceeds on in the 8 weeks following the disbursement of the loan that would give you forgiveness. And first and foremost is payroll costs, but you also see mortgage interest, rent obligations, utility payments. And one of the caveats there is that it has to be something that was an obligation you incurred before February 15th, which is when sort of the relevant period for this PPP program starts. So before, you can't have just gone in and signed up for a mortgage after the coronavirus pandemic hit and say you want to pay on that. It has to be something pre-existing. And then we'll get to in a minute that there can be a reduction in the amount of forgiveness based on a reduction in employee count or compensation. So this gets a little bit complicated, and I'm going to try not to make the cardinal sin of lawyers trying to do math for you. But at any rate, there are certain formulas that you have to apply to determine how much of your loan forgiveness would be reduced based on employee count issues or compensation issues. And so the concept is that if you can retain your employees at about the same level as you had pre-COVID-19 in one of these time periods that are listed here, then you would get full loan forgiveness or not have a reduction, certainly. And conversely, there's a little bit of a wiggle room that your salaries could be reduced for your employees by, it could be 75% of what they had in the pre-COVID period without further reduction based on the salary. Although, as we'll see, if you've got to spend 75% of your loan on payroll costs, it may be that 75% reduction, the reduction in salary by 25% is not something you can achieve anyway without violating the 75% requirement. But you get to pick one of these periods of time as sort of the benchmark for your pre-COVID FTE level, and then you measure your average FTEs during the 8 weeks following the loan forgiveness period, and compare it against the two. And then here's how that works. Well, let me just go back real quick. So you do a division that essentially says if the ratio is that you had fewer FTEs in the 8 weeks following the loan and in that pre-period, you're going to get a reduction. So if you had 9/10 of the employees, you would get a 90% of forgiveness and not the full 100%. So there's also a salary-based calculation, and that is basically, as I said, there's a 25% allowance that you could reduce their salaries by up to 25% before this reduction kicks in. But if you reduce it beyond 25%, say you cut their salaries by 50% during the 8-week period following the loan compared to what it was in the prior full quarter of employment, pre-loan, then that reduction below the 75% level is reduced from your forgiveness. So we have a little bit of an example here. An employee making $6,000 a month in the prior quarter that uses the benchmark, and you're only paying them $3,000 per month in the 8 weeks after the loan. So that's a 50% reduction. So you were allowed to take a 45% reduction, and so you could have paid them $4,500 per month without having any reduction based on this forgiveness issue. But because you only paid them 50%, then the difference between what you paid them and the 75% of their salary, $1,500 per month for 2 months, is the reduction in the forgiveness.
Okay. Frank, this is Mike Lockerbie. Do you or would anybody else have any insight as to how that 8-week period is calculated? Does it begin when the loan is originated, or is it any time during the period in question?
I think it's pretty clear that it's after the loan origination based on the guidance they've issued, and if they have to, it's actually, and when I say origination, it's the disbursement of the money. So I think they say once you've been approved, the lender has 10 days to disperse the money, and once they disperse the money to you, that's when the 8 weeks for the loan forgiveness period would kick in. And so that's how they would measure you. At least that's my understanding of the guidance to date. Whether they clarify that and say you could go back and backdate it to starting on February 15th. I doubt that because the idea is to sort of provide payments to employees that they wouldn't be otherwise receiving. So particularly if your employees were not laid off at the time and you've already spent that money, it's hard to see how you're now respending it in the after the loan's been dispersed. But so I think the intent is you get the loan, spend the money over the next 8 weeks. That's how they measure your forgiveness. And then there's a little bit of leeway, that you can still spend it through June 30th if you don't spend it all in the first 8 weeks, but it's just that what's spent beyond that 8 weeks is not forgivable. And then the program effectively ends on the 30th of June, and we'll see if that changes. They might extend the date or clarify it in one of these fixed legislations they're talking about, but that's how I understand it. So there is an exception or an exemption from the reduction in loan forgiveness. And again, I'm not going to spend too much time on this, but essentially if you get back to full employment by June 30th or full salaries by June 30th, then the reduction that you had before then isn't held against you. And I think this is one that's kind of confusing to understand how it plays out. So I think we're going to need to get more guidance from the SBA when they issue the rules for loan forgiveness. But, if you get a loan now, 8 weeks will end before June 30th. So you'll have, at least 2 or 3 weeks, maybe 4, before June 30th. And that will give you a window that even if per the 8 weeks you wouldn't be fully at forgiveness, if you get back there by June 30th, it won't be held against you. So for forgiveness, you're required to, you're to submit the request for loan forgiveness after completion of the 8-week period. You need to document your FTEs that were in that 8-week period and what you paid for payroll costs and the other allowable forgivable costs. And so the lender is supposed to make a decision within 60 days, and there's no details yet. This may be forthcoming, but no details yet about if you disagree with the lender about whether an amount should be forgiven or not, what your recourse is. Again, no more than 25% of the loan forgiveness amount can be based on the non-payroll costs. And as mentioned before, that's because of the view is the intent is to provide paychecks to the employees first and foremost. There have been some questions for people who've been applying so far. And one of the questions is, what do I need to provide? We got the smart aleck answer here is, that depends on the lender. These are loans are being issued by private lenders, authorized by the SBA. And so if they're asking you for specific documents before they'll approve your loan application or submit it to the SBA for approval, then you obviously need to answer what they ask for. And here's an example of what some banks have been asking for. It really varies lender to lender. The SBA, I think, has tried to streamline this and try to make lenders more comfortable on not needing as much documentation as they might normally. But again, if your lender is saying, I need this document, and you disagree, not a lot of good options for you. You can go to try to go to a different lender, but probably better to make them happy. I think we had one other question about, and this is one that's come up pretty frequently, is with these shutdown orders. So the Act says you have to spend 75% of the loan, or the rules from the SBA say you have to spend 75% of the loan proceeds on payroll costs. And the question comes up, well, my business is closed. I've been told I can't have people coming to work because I'm a non-essential business or whatever the situation might be. I cannot open up my business. So you can't possibly mean that I have to spend money on these employees to sit at home and not come into work. The answer is yes. I think that is exactly the intent. Again, it's the Paycheck Protection Program. And even if those employees would otherwise be able to draw unemployment, the whole idea of the federal government giving you essentially free money that's forgivable is that you're going to be paying these employees, taking them off unemployment, putting them back on the job, even if they have to sit at home. At least they're drawing a salary, they're getting the employer-provided health benefits. That is seen as the purpose of this program. So I do think that if that 8-week period you're technically shut down and not able to come into work, you still are expected to try to rehire those employees, put them back on payroll, and spend 75% of the proceeds on those payroll costs in that period. The SBA application for the PPP asks for the lenders to confirm that there's documentation to provide how you calculated your maximum loan amount, your payroll costs for that. But they also made clear in guidance that you're not required as the lender to drill down into the nitty-gritty on how those numbers were generated. You're allowed to rely to a large extent on the borrower's certification and attestation that those numbers are accurate. And so, again, there is some level of documentation to show your FTEs and your payroll calculations, but the level of documentation is pretty much built on a self-attestation level, so there's not a lot required. Again, there's a follow-up question about whether you have the remainder of 2020 to use the PPP funds, or do they all have to be used by June 30th, 2020. I don't think the SBA has spoken clearly to that point, but if you read the Act, it talks about that the authorized uses of the loans are for the covered period, do X, Y, or Z, spend it on payroll costs, whatever. The covered period is defined as ending in that section of the statute on June 30th. So I think the read is that you are expected to spend the proceeds June 30th. It's not intended to be a low-interest loan that you can just pocket and say, I'm not going to pay my employees until I get to go back to work. I think the intent is that you spend it by June 30th, and whatever you don't spend by then is arguably, you can't use. But they haven't really spelled that out yet, and hopefully they will in the guidance, because that does seem to be the way the Act is structured, is that you're supposed to use the money during the covered period. And again, the covered period ends on June 30th. So finally, some quick pointers. This is a first-come, first-served program, so there's a need to act quickly, but you also need to act prudently. As Mike pointed out, don't just leap if you don't have a good faith basis to think that you're eligible. Make sure you find out what your lender wants and needs so that you can give it to them and have your application process smoothly, and get the documents together to establish your employee number, salaries, mortgage, rent, utilities. And again, be on the lookout for further guidance. There's been a tranche of guidance that's been issued in the last week or so. They are updating the FAQs, not every day, but every so often. So you can keep on the lookout for those. And that's the other thing I would say is if there's an issue about affiliation, it's probably a good idea to put your cards on the table and say, we think we're in a gray area. Here's why we think we're not affiliated. If you're putting your cards on the table in the applications, explaining things, it's probably a safer place to be than just not disclosing information and having someone come back after the fact and say you were trying to hide something. So that's not on here, but I would add that as a pointer as well. So I think that takes us to Holly, who's going to handle bankruptcy and restructuring.
Thank you, Frank. And as I mentioned at the outset, as our webinar series goes on, we will be spending more time on the issue of bankruptcy and restructuring. But we're fortunate today to have as a presenter to introduce us to this topic, Holly O'Neill, a partner in our Dallas office. And Foley has had a Dallas office now for a little over 2 years, since April 1, when we merged with Gardier, based in Dallas. And with that merger, we picked up the Dallas office, Houston, Austin, Denver, and Mexico City. Holly was the chair of Gardier before the merger and continues to serve on our management committee. In her spare time, she's also a nationwide expert in bankruptcy and restructuring. And the object today is mainly to get everybody up to speed on some basics of bankruptcy and structuring before next time we do a deep dive into how franchise and distribution systems may be affected by bankruptcies on the part of people in the supply chain, dealers, distributors, and franchisees, and hopefully not the manufacturer or franchisor itself. So Holly, with that, I'll turn the floor over to you.
Thank you, Mike, and thank you for everyone participating today. I could spend a webinar of a couple hours on this topic, and Mike is limiting me to about 5 minutes, so I'm going to go through some just high-level topics regarding bankruptcy and restructuring. Obviously, Frank's topic was the main attraction for this webinar. What we're going to cover very quickly is whatever I call it what everybody needed to know before the pandemic, mainly because there are some new provisions in the CARES Act that are temporary. So I wanted you to know sort of the norm and then what's in place that's temporary that kind of changes the norm. We're going to talk a little bit about what bankruptcy is, just a general overview. Primarily for the participants on this call, I think the options are really between 2 chapters of the bankruptcy, Chapter 7 and Chapter 11. So that's what I'm going to focus on more particularly, and then just some general things to consider that may be triggers for the need to commence a bankruptcy case. We're going to talk about a couple of the legislative developments that are very, very current. One was the Small Business Reorganization Act of 2019 that recently went into effect, just ironically, unrelated to what's going on, that is helpful. It became effective in February of 2020. It was passed in 2019. And then the CARES Act, and I'm going to overlay the CARES Act provisions that relate to the Small Business Reorganization Act, which I'm going to call the SBRA. So what is bankruptcy? Basically, it is a formal in-court proceeding. There's a statutory framework under federal law and rules. That's what we call the Bankruptcy Code. It looks like it's a small little code that is really not very intimidating, but it's couldn't be anything more to the contrary. And it's obviously got rules. There's a specialized bankruptcy court and bankruptcy judges that deal with just implementing the bankruptcy code and rules in conjunction with restructuring or liquidating a company. The bankruptcy code has a protocol or a system for troubled businesses of both reorganizing and an orderly liquidation. So let's talk about what is bankruptcy and what some of these chapters are, some of which you may have heard of. There are basically 5 different main chapters under the Bankruptcy Code. There's Chapter 7, which is primarily a straight liquidation where a trustee is appointed. Chapter 7 is utilized for both individuals and for businesses on an individual basis, which we won't talk about today, but there are exemptions that assets are protected that is not applicable to businesses. Nonetheless, Chapter 7 is where a trustee comes in, takes over the business to just liquidate the assets, monetize any of the assets, and distribute them ratably to the creditors. Chapter 9 is for municipalities. Chapter 11, which is the main bankruptcy provision for businesses, as you may be aware. One of the misconceptions about Chapter 11 is that it is just for reorganization. It can also be used to orderly transition the business to a new buyer. It can also be used to actually wind the business down in an orderly and structured fashion to maximize the return for the creditors. There's Chapter 12, that is for family farmers, and then Chapter 13 deals with individuals and can also include some debt, business-related debt, if that individual is operating as a sole proprietor. We're going to focus today on Chapter 7 and Chapter 11. I'm going to take Chapter 7 first. That, as I mentioned before, is basically a trustee comes in to liquidate what is left of the assets of the company. It's basically operations have stopped, and cannot be resumed. A Chapter 7 usually is handled on a more expedited basis than a Chapter 11. It is less return to the creditors typically because it's fairly destructive to value. It tends to be you're not able to get fair market value for the business. It really is more of a fire sale situation, and thus creditors obviously recover less. This is just a straight shutdown of the business, but in an orderly fashion. A Chapter 11, and I put standard on the slide because we're going to talk a little bit about the SBRA modification of this, but a standard Chapter 11 is either a reorganization or it can be a liquidation or a sale process. The benefit of Chapter 11 is that the ownership stays in place during the process. That doesn't mean upon exit from the process, but certainly during the process, there is not a trustee appointed, and the current management of the business can continue to operate. And the idea being that the current management can maximize the return for the creditors, is in a best position to consider alternatives for hopefully reorganizing the business, et cetera. It is a longer process, maybe more complicated, and certainly in all instances, in my experience, is more expensive than a Chapter 11, because that can be both good and bad. I say that because occasionally, especially in a circumstance like we're in right now, where there's been such an abrupt stoppage across the platform, bankruptcy, it provides what's called an automatic stay, stops all litigation, stops all actions against the assets of the company and against the debtor itself, and gives you a breathing spell to try to get through certainly abrupt changes in the business. And so for that there is a cost to that in terms of time and administrative requirements of a bankruptcy. But nonetheless, that breathing spell may be exactly what is needed to get through the trough, particularly in a crisis. Creditors have more rights and protections in a Chapter 11, and thus, consequently, hopefully would be more protected than in a Chapter 7. And as I mentioned, the management stays in control as a debtor in possession. There is no trustee that is specifically appointed for the estate. Some of the triggering events that may lead to a bankruptcy, and we have on our Coronavirus Resource Center, we have a whole article regarding director and officer liability issues in the zone of insolvency. I cannot get into that today because of time constraints, but at a minimum, I would certainly urge the audience to look to our Resource Center for at least that article on D&O issues in the zone of insolvency. But obviously triggering effects to a bankruptcy or absence of liquidity, either loan maturities or funding terminating or revenue stopping is much the case today with many businesses. There are triggers or significant litigation that is consuming a lot of resources of the company, and I'm not going to go through every one of these. Overwhelmed by multiple creditors and legal actions. And obviously I added pandemic at the bottom of this list, which is not something that typically, in my experience, we've had, and is hopefully we won't ever see it again. But that is it's pushing a lot of distress across the spectrum. So the legislative developments I want to focus on for a few minutes are primarily the Small Business Reorganization Act of 2019. It went effective in February of 2020. And also, approximately a month or so later, the CARES Act came along, which was signed into law on March 27th. The SBRA, as originally drafted, provided significant relief to small businesses distressed for any reason, but certainly for the overlay with the changes or the modifications under the CARES Act would certainly help in the current pandemic environment. Under the SBRA, and I'm going to talk about it just very briefly as it existed before the CARES Act, it was intended to be a very, very streamlined Chapter 11 process and much more cost-effective for debt restructuring. As originally passed, it was limited to small businesses with not more than approximately $2 million in combined secured and unsecured debt. So relatively small businesses, I would say. It has been increased by the CARES Act, and that's what's notable because it increased the debt limit, if you will, to $7.5 million of both secured and unsecured debt. And this change applies to cases that are filed under after the CARES Act became effective and is applicable for 1 year. Now, we don't know right now if that's going to get extended, so this would be a temporary change under the CARES Act to increase the limitation from the $2 million as the SBRA was originally drafted to $7.5 million limitation. Obviously, this will allow more businesses to take advantage of the SBRA provisions. So let's talk about the protections under the SBRA. As I mentioned, more cost-effective. The provisions in the bankruptcy code the timelines are much more accelerated, meaning that the company can get in and out of bankruptcy quicker, and that is more cost-effective. Maybe the most significant provision of the SBRA is to allow the retention of control of the business on exit, even if all of the creditors are not paid in full. In normal bankruptcy, there's a concept called the absolute priority rule, which basically, unless all the creditors are paid in full, the existing equity cannot retain their rights as equity owners. There are some exceptions to that if new money is put in, but typically speaking, if the creditors aren't paid in full, equity being at the bottom of the stack cannot maintain its position. That is a modification under the SBRA for the ownership of small businesses to be able to maintain their ownership through a bankruptcy process without paying all the creditors in full. So obviously that reduces creditor leverage and gives more flexibility for the business owner to try to maintain the business and get through what is otherwise a crisis. It avoids the formation of a creditors committee, which can be extremely expensive, and that's a layer of cost that under normal bankruptcy outside the SBRA, the company is responsible for the payment of the professionals that represent the creditors committee. So it's an additional layer of expense and can be very expensive, and that is not applicable under the SBRA. As I mentioned, the retention of equity without paying the unsecured creditors in full is significant. It also alters the provisions for how creditors can accept or reject the reorganization plan, and the disclosure requirements are much less stringent. And then finally, the discharge, you get a discharge from even unpaid claims upon completion of payments under a reorganization plan, so long as it's within 3 to 5 years. That was a very quick overview of bankruptcy, and I appreciate your time. And Mike, I turn it back over to you.
Thank you, Holly. And as I said, we'll be covering these topics in greater depth in the weeks to come, including, first of all, the issue of force majeure clauses, which are often in leases, supply chain contracts, distribution agreements, franchise agreements. There are more materials about this on the Coronavirus Resource Center website. It's important to bear in mind that force majeure, this is taking all of us back to first year of law school, is essentially a contractual right, and we always think of it as wars, acts of God, etc. Pandemics, frankly, were never on my radar screen before. The biggest hurdle, though, to trying to invoke such a clause, and this is important to bear in mind whether you're trying to invoke one or trying to avoid having it invoked against you, is that the party claiming force majeure has to show that the event actually prevents performance. In other words, there's no alternate means to fulfill the contract. Increased costs alone are not enough. Performance has to be impossible, not just more expensive. Again, it's an issue of contract. There are definitional issues and notice requirements. Also, from a business standpoint, there's going to need to be a plan B if force majeure is being invoked to deal with the supply chain issues in the interim. If there is no force majeure clause in the contract, and that's probably rare, but there are common law doctrines of impossibility, impracticability, frustration of purpose, and then to the extent that the contract is deemed to be one for the sale of goods under the UCC, there's the doctrine of commercial impracticability that may come into play. Insurance is another topic we'll be covering quite a bit. Just bear in mind that we're already starting to see tort claims against franchise systems in particular, to a lesser extent, manufacturing distribution systems. One issue that comes up is negligence, whether there was failure to warn, inadequate precautions, inadequate sanitation, etc. These generally raise issues under commercial general liability insurance. Many people have questioned whether business interruption policies can be invoked. That requires reading the policy, but typically coverage applies only if there's physical injury or physical damage, and it's not clear that such a claim can be based upon illness of people necessary for business operations. Last but not least, those of you who are regular attendees at our distribution and franchise seminar know that we're always talking about state franchise and dealer relationship laws. The laws obviously haven't changed as a result of the pandemic, but I think it's safe to assume that under the current situation, something that might clearly be good cause may not be good cause as a practical matter as these statutes are applied by courts, especially in equitable cases where somebody is seeking a preliminary injunction or TRO. So that's something to keep in mind. I know we're already over the time allotted, and so there were some questions already that had gone unanswered, and then if people have others, please feel free to submit them, and we will try to answer them to the extent we can. Thank you.
Yeah, so there were a couple questions about the SBA loans, the PPP loan program. The first one was about whether companies are able to defer the receipt of the loan for several weeks to try to essentially defer the use until maybe some of these shutdown orders have lifted. And the SBA clarified that in an FAQ response within the last couple of days that really says no. That essentially the 8-week period for loan forgiveness begins after the loans are dispersed, the proceeds are dispersed, and if the lender has 10 days that they have to do it. So that response was, I think, intended to address this particular question of whether, the lender, okay, my loan's approved, but can I wait before you give me the money so my 8-week clock doesn't start? Or, when would my clock start? Can I defer that to later on? And they're pretty clear that you can't. So once it's approved, the lender has 10 days to disperse the funds. Once the funds are in your account, your 8-weeks start, and that's when your forgiveness period starts. Another question was about whether, as an individual self-employed or individual contractor, whether if you get distributions as opposed to just employment income, salary, can you include the distribution amount as part of your payroll costs? I'll caveat this by saying I'm not an employment attorney, so there may be a different answer if somebody can tell whether that is the net proceeds or self-employment proceeds. I think is one term that's used in the definition of payroll costs for an independent contractor. But to the extent that that's really more ownership income than it is employment salary, I would say probably not. Again, the idea here is not necessarily to make you whole for what you would have experienced prior to these disruptions, but to make sure employees are drawing some salary, and there's that $100,000 cap. And I'd also say that applies particularly to how you pay. It's on a prorated basis for the 8 weeks. So you can't pay yourself more than whatever $100,000 over a year prorated to 8 weeks is within that 8-week period. So that might knock out the distributions, but I also think that to the extent it's considered more ownership income than it is sort of profit for the business than it is salary, that would probably be a problem as well.
Thank you, Frank. We're more than out of time, but I want to thank everybody for joining us today, and we do look forward to seeing you live and in person at our regular distribution and franchise seminars. But in the interim, we'll be having at least one more, possibly more, webinars focused on issues related to the coronavirus, including one focused on the issues that we'll hopefully be facing soon about getting back to work. So thank you.
Thank you.
And with that, today concludes our live webinar. If you have any further questions, please feel free to either type it in the chat box or send us an email. Thank you so much and have a great day.